several ways in which it may be possible to challenge or contest a will. The first is if the document isn't actually a will in the first place. For a document to be a will, it only needs to be in writing, made by the testator, that's the person making it, who intends that it's a will. It needs to be signed by the testator, it needs to be signed by witnesses who see the testator sign it, and if that's the case, you have a valid will. If those requirements aren't complied with, then you don't have a valid will in the first place. The next way in which a will could be challenged is if the signatures that are on the will are not in fact the signatures of the person who appears to have signed them. In that case, what you've got is a fraud or a forgery, and again, you don't have a valid will. There are three other legal ways in which a will could be challenged. The first is that the person making it doesn't actually have mental capacity when they make the will. That's classically where they have very old age coupled with Alzheimer's or some other form of dementia, but it can be any similar situation where they don't have capacity. The second is where the person who's making the will makes a will, but it isn't their intention to make a will in those terms. They have been subject to undue influence by the person who's actually trying to persuade them to make the will in those terms. And the final one is where they don't have knowledge and approval of the contents. So they do mean to make a will, but in fact they don't really understand what's in it, and so they don't actually make a valid will. Beware though, because if you do successfully challenge a will, you may simply have revived the earlier will, which left you even less money. Now, if any of these matters cause you any concern, you really ought to seek specialist legal advice from your trusted advisor.